Thank you very much, Shelley. That's a nice framework to talk about what's going on here in Santa Barbara County. I was interested in that there being no monitoring of bounty hunters. In 1986, I was a young, naive graduate student working in downtown Los Angeles at the front counter in the criminal courts building, and it was not unusual for bounty hunters. These are big, hulking guys with weapons on their sides, bringing in sometimes sweating and bleeding defendants to surrender them. Now, I grew up in a small town in north central New Jersey. That was an awakening for me, and it was very nice to come to Santa Barbara County. I don't think I've seen that here once. But even after all that time, to have there be no monitoring of bounty hunters is an interesting fact to learn. So I'm going to talk a little bit about what's going on in Santa Barbara County and take you through a brief, I left my documents, hold on. Just a quick history of pretrial services and bail in Santa Barbara County. The first pretrial system operated in Santa Barbara County was in 1977, and it was then operated by the probation department. In 1981, the Santa Barbara Municipal Court then took over that operation. In 1985, the Santa Maria Bail Review Unit was created, and in 1995, it became known as the Pretrial Services Unit in the then Santa Maria Municipal Court. In 1998, some of you will remember AB 233 was a constitutional amendment to merge the courts, and the courts merged in 2000 in Santa Barbara County. And then for the next 15 years or so, we continued to operate what was essentially two different pretrial units in Santa Barbara County. Evidence-based risk assessment instruments, or a risk assessment, was a new term to me that I started hearing when the probation department was talking about COMPAS. And then they drug me to the table in something called the Transitions from Jails to Community, when I thought, who are these people and why are they imposing themselves on the court? The pretrial world is ours, go away, leave me alone, I've got enough to do. But in fact, what they were bringing was some science to the table that I just wasn't familiar with, and I was resistant to that change. And it compelled us to look at increasing opportunities to improve pretrial in Santa Barbara County. And then I started hearing in jail overcrowding conversations, some polite, some not, that there was a difference between the North and the South, and I was stunned to learn that. But there were comments that the South County was releasing people with more frequency, and the North, the cowboys up there just wouldn't let go of anybody, and if only the North were more like the South, the jail wouldn't be overcrowded. Well, that's a remarkably oversimplified statement, but there were in fact differences in the two that really needed to be looked at. The South was in fact using more creative options. I had no idea what Laura Lowe's was doing out there at that time. And we just didn't have, remember I was in charge of just the North County then. It wasn't until I became responsible for the whole county that I started looking at things on a more global perspective. And while she scared the hell out of me with some of the things she were doing, they made sense. And that didn't mean that we shouldn't be looking at doing them in a more effective way. And so then we started looking more closely in 2014 at evidence-based risk assessment instruments. In 2015, we consolidated the two separate divisions into one unit. And I found myself sitting in front of the Board of Supervisors making presentations on metrics and data and digging into questions about what it was we were presenting. And in talking to the two separate divisions, I found that we were talking to two separate divisions. In fact, there were differences in the data that we were reporting. We were using the same term to refer to different functions in either end of the county. So I was listening to Tim talking about building a common language across the US. We started doing that in Santa Barbara County, and that was essential, and a lot of work went on to try to level the playing field within the employees within that division to understand what we were talking about. I'll give you an example. Failures to appear were a metric that we reported, but we were only counting failures to appear if they failed to appear at the first appearance. Subsequent failures to appear were not recorded. Well, that doesn't seem like a really thorough metric, and I think we need to improve those. So a group of us went to Sacramento with the sheriff and a bunch of others on the first pretrial summit in 2015. Afterwards, we applied for that recidivism reduction fund, and it's funny to look at that 5.3 million at the top, and we shared 45,000 with 3 other courts at the bottom. But some of that was just that we weren't at a place where we could collectively really successfully compete for that. We needed to clean up what was going on in Santa Barbara County in our own pretrial division. But we got a small planning grant, and we were able to hire the Mark Carey Group and Mimi Carter, which some of you have met today. And she is helping us design a collaborative and research-supported, consensus-driven pretrial risk assessment instrument, or risk assessment, the instrument is one we're using, including the expansion of pretrial supervision. The Community Corrections Partnership, which was created through AB 109 and the Public Safety Realignment Act, also has a keen interest in what's going on in the area of pretrial because it affects recidivism. And so they agreed to fund the balance of what we needed to keep Mimi Carter here with us. So when we were coming together, I think I skipped, with Mimi, we first decided we can't do this on our own. And in fact, I made a mistake. I tried to do this on my own. I didn't need the rest of you, I thought. It's my responsibility, I'll handle it. And that's just my own ignorance at the time of just how important it is, this sophisticated interdependency of these justice agencies. But I learned that lesson. And we built a team, and there's a lot of people on the team. And here's the members of the policy team. And then we had a working group, and a lot of work has gone on in that group. And I want to thank the members because they really have been contributing and maturing in the process and sophistication and awareness of what the pretrial world is all along this path. So we talked about using a risk assessment instrument to better advise decisions. It's not a replacement for the judgment of the pretrial officer, but it's a proven mechanism that helps inform the decision of our professional pretrial services officers throughout the county. And we know that that can increase the possibility for us to release people who shouldn't be in jail. That doesn't mean we're releasing everybody, because there are a number of people who probably should and are in jail. But the more we looked at it, and the more we looked at the way to inform our decisions, we found persons on the lower end of the spectrum who we could release on a more frequent basis. Now, some of the acceptance of the risk assessment instrument is our own tolerance for risk. And we are obviously not rushing down that path to take more risk. We're doing it gradually. And Laura and her folks have been using the Virginia Pretrial Risk Assessment Instrument alongside their normal procedures, and are increasing persons on the 0, 1, and 2 score. And I'll talk a little bit about the instrument in a minute already. So while we're not totally dependent on the instrument at this time, it is informing decisions throughout Santa Barbara County. But we wanted to really do a cost-benefit analysis. If we're effectively releasing people, what is the benefit to the Sheriff's Department and the criminal justice system in terms of hard dollars? So Tom Alvarez, right, the county budget administrator, is a part of our group, and Paul is here. They look sharply. They have a fresh box of pencils at every meeting to try to figure out how many jail bed days could you affect, and what is the cost per jail bed, and what's the average length of stay of somebody on a pretrial basis. And if you increase a greater percentage of those who score 3 or 4, what will the impact be on the community financially? Okay, I got that question in my head. I don't have good data, and we're working with the Sheriff's Department to try to get that data. Who's in the jail on what charges, and who could be served by, or who potentially could be released by adopting some increased pretrial supervision, is something we have to work on. We've identified a problem, but we don't know the scope of it, and we don't know the impact yet. but we know that we can start working on it now because there are some proven mechanisms out there, and that's what we're doing. So in trying to come up with the metrics, conversations with folks around jail overcrowding, talk about that. What's the percentage of the pretrial people in the jail, and how does that affect, Shelley was talking about this, how does that affect who gets out of the jail? If we have people who can't be released because they're in the jail pretrial, if we could reduce that number, then those who are sentenced could serve their legitimate terms and help improve faith in the justice system. So there's some really interesting metrics, and if you're a data geek like me, you can find yourself sort of binge watching data. I do that on Netflix with some shows, because they have this great way of massaging the data. But the Board of State Community Corrections has established reporting guidelines to evaluate the jail population. And they've looked at the pretrial jail population statewide. And it ranges from a high of 85% of the jail population to a low of about 45%. Okay, I'm going to overwhelm you with this next group, okay, right? It worked. Okay, so this is a graph of the 58 counties and the pretrial population, and you can't read any of the numbers from where you are, but let me help you. Trust me that it's a low of 45% and a high of 85%. But here in the center is the average for California. 63%, this was done in 2014, I couldn't find the more updated stuff, but 63% of the county jail population in California is a pretrial population. In Santa Barbara County, it's 70%. And you know, on some days it's 71, some days 73, depends on which newspaper I read or what meeting I'm at, it varies between those. But at the time we took it, it was 70%. So we're not the worst, right, when it comes to the pretrial population in jail, but we certainly have some room for improvement there. So some of you will remember when I started talking about this in 2000, do you have a question?
If you don't mind.
No, I don't mind.
If you go back, I just recently was educated to the SBC definition of includes inmates who may be sentenced on one charge pending or still pending trial on another. And I'm just curious if, like the sheriff was wondering if it value meeting some kind of category in terms of people who were solely pretrial as a group. Does that BSCC definition impact at all where we want to go?
So I was asked to repeat questions. But let me, I get what you're at, and Shelley pointed this out. You're right. There are people who are in the jail, pre-trial, right, on one unadjudicated case, but are in jail already on another case. So if I get a probation violation, I pick up a new case, right, I'm sentenced already on that probation case, but I'm pending adjudication on the other one. You're right. That can I affect the release of that person under these conditions? Probably not. So yes, there's value, but that definition hasn't been changed by the Board of State and Community Corrections, and so it's the best statewide measurement I have right now. In fact, my jaw dropped when I read the article in the Independent that mentioned a new number on the jail. It said that, I think Kelly Hoover had reported that, 52% of the jail population was now pretrial population. Well, that was a calculation, as I understand it, based upon your clarification. And I was thrilled because I was done and I was going to cancel this presentation. But yeah, we have to understand who is in there and who is truly eligible for pretrial release before we can establish a valid metric and come up with a cost-benefit analysis. And your example highlights the difficulty in that. You have to define the scope of the problem in order to identify a reasonable goal. This includes the question is, does this include misdemeanors and felonies? This is the total jail population without regard to misdemeanor or felonies or gender. I've seen charts based on that as well. So this is just the total jail population as I understand it. So I think San Francisco is the highest pretrial jail population. I don't know. I don't have the breakdown on misdemeanor versus felony. Okay, so back in 2015, the first 6 months, I took a look at what we were doing at that time in both the North and South County to get a sense of what percentage of people were being released, and were there more people being released in the South County than in the North. And given the way we were defining it then, it was true that 13% of those eligible for release were being released in the North, and 32% were being released in the South. This chart reflects that. So let me talk a little bit about data that we've collected recently in 2016. And this chart, it's better when I show you. This is cases interviewed. So the OR folks interview a lot of people who they never complete a final report on because those people bail out or have some other hold that removes them from the process. So they spend a lot of time at the front end interviewing people that end up not having a report completed on them. It's an average of 218 interviews in the North and 216 in the South. I was surprised by that because over the course of the year, those have leveled out. And then how many do they actually complete? Look, it's about half. 120 in the North and 104 in the South. And then how many actually get released on OR of those? On average, 20 in the North and 25 in the South. So we've got to get some good data on why that difference. Why is it 25% more on average? Anecdotally, I have heard it's because the charges in the North are more egregious offenses, and there are gang allegations with greater frequency in the North that make them ineligible for release. But I don't have solid data on that. Are you nodding in agreement, Mag? Okay, and domestic violence. Domestic violence, thank you very much. That's the number one felony in Santa Barbara County, according to my most recent statistics, domestic violence. And then how many of those were denied an OR release? 100 in the North and 79 in the South. So then I took a look at side-by-side data to try to get a sense of what percentage overall are released. 24% of those cases where we complete a report are released in the South, and 17% where we complete the case in the North. Okay, so that's just some background for some of the data that we have. We really have a need to get some more solid data in order to figure out whether we're doing any good, right? If we don't have some performance metrics, how are we going to know that we're succeeding? What you count counts, and you can't manage what you can't measure. We're shooting at a target, but it's dark. We've got to really shine the light on what our target is. But we adopted the 3 M's, nuts and all. Our goals are to maximize public safety through recidivism reduction. And you heard the story that if you can reduce the pretrial detention, you have a greater probability of reducing recidivism on the back end. Maximize court appearances. We want to make sure these people actually get back to court as they're supposed to. Maximize pretrial release. But there are important factors in that process. We have to make sure that it's fair, it reduces harm and protects the public. The decisions are informed with valid research data, and that it's, wait, what's the word you used? Parsimonious. Parsimonious. Use that one. It's cost effective. So our proposal is we're moving forward with the Virginia Pretrial Risk Assessment Instrument. And Judge Regali earlier asked about the other instruments. And we looked at Kentucky, Ohio. Is there one in Tennessee as well? I don't remember. But we looked at a range of these and settled on the VPRE, you'll hear us call it. And then we're going to train all of the pretrial staff. Now, many of them have already been using it, but we're going to make sure that we bring in the experts to make sure that we're using it correctly across the county. We're going to validate the instrument in our county to take a research institute to take a look at the data that we're collecting and make sure that it fits for our county. There are a couple of things that have come up, and I'll mention those again in a moment, about the instrument that we think it could have additions that would benefit us. And then introduce supervised pretrial release. So let me talk for just a bit about the Virginia Pretrial Release Risk Assessment. I noticed the stack is gone in the back. So that must mean that most of you got one of these. If you haven't and you want to get the report, it's the last one. The most recent one came out in November. And I was talking to Judge Kelly during the break about these slideshows and the reports. And we think it makes sense to create a web page on our public website just focused on pretrial. So in the coming days, we'll post this information there. And these good folks on the side, Silvio Moto and his team, are recording today's proceedings. So if you know you want to share this information with anybody, we'll have a link up there for a rebroadcast on this as well. So we'll make the materials and the most recent report so you can take a look at this more closely afterwards if you'd like, or share it with others. So the VPRE is a list of 8 questions, and it scores a low of 0 to a high of 10. Frankly, 5s to 10s are highs, and 5 for us is our level of intolerance. We're looking at 3s and 4s right now and moving there gradually. So in that instrument, you'll see, let me jump ahead, these questions. And here's the 8 factors. Charge type. Do they have pending charges at the time of arrest? Do they have outstanding warrants? Their criminal history? Are there 2 or more failures to appear? I was very interested to hear that Colorado doesn't measure this because this is important for us. 2 or more convictions? Length at current residence? Are they employed, or are they the primary caregiver for a child? And do they have a history of drug abuse? In Santa Barbara County, I heard this figure somewhere that Santa Maria is among the most unsafe communities when it comes to driving because of DUI offenses. That's a startling fact. And so it's interesting and obvious then that someone would be concerned about alcohol use. And why doesn't the VPRE measure for someone's propensity to abuse alcohol? We're looking at an instrument called Unco, which is actually an acronym for the first letter of 6 questions in there. That is a screen for someone's propensity to use alcohol, abuse alcohol or substance abuse, other substances. And we're also looking at a screen mechanism for mental health issues. There's, last week I think it was, the sheriff and another team of folks in Santa Barbara County, I'm sorry the courts couldn't make it there, went to a stepping up introduction in the state that is looking at diversion for persons with mental health to avoid getting them into the criminal justice system at all, so that we don't have to do the assessment that they would be diverted. So it looks like some good work is going on there. But until then, we're still looking at adding a component for some mental health screen in the pretrial process. We think it makes sense to move towards some increased forms of supervision, especially as we move higher up the risk scale. And I saw a list earlier that was very helpful. We're looking at check-ins, call-ins. Right now that's going on, those persons released on pretrial are ordered to check in once a week or twice a week with Laura and her staff. And that can happen either in person or over the phone. And that is, in my mind, a form of supervision. Electronic monitoring and global positioning, including some stay-away areas. There are ways to make sure that persons who are GPS don't enter exclusion zones, I think the phrase is. SCRAM, which is being used now and increasingly, secure continuous remote alcohol monitoring, drug testing, and field supervision. We submitted a proposed budget through the CCP work group, the Community Partnership Work Group, yesterday, seeking funds to pay for supervision. We're pursuing a couple of probation officers operating out of the PRRCs, the Probation Report and Resource Centers, that already provide services and have mechanisms and infrastructure built that would support the sort of supervision that we're looking for in field supervision. Those positions would oversee the GPS, SCRAM, testing, check-ins, field checks, and also allow us to have an ability to arrest somebody who's not in compliance or is not performing correctly. The real work that we've got to do in the work group is to draft these protocols. And we have to make sure that we have written procedures in place and that everybody agrees on what those procedures are and those protocols for when someone is doing well on supervised pretrial release or when someone is doing poorly, and that the whole criminal justice system understands what those are. So our next steps are the training of all the pretrial staff. That will be happening before July. We have to reach an agreement with the Research Institute to validate our instrument. We're going to then begin using the vPri instrument more aggressively. I think we can start reminding defendants now about their court appearances, even before we buy some high-tech solution. If we have any downtime, I think it makes sense to start calling people on some prioritized basis to see if we can affect that FTA on those persons who are already released. And then if we are able to get the funding through the CCP, we'll look to expand the pretrial supervision component. So that's my wrap-up. I moved from an uncomfortable place. I was in my zone of disequilibrium for a long time. In fact, I was dragging my feet when it came to change in pretrial. But I think there are others who've been in that position and are moving there with me. And you can see that it's happening not just here in Santa Barbara County, but across the nation and throughout California. In fact, that special committee that the Chief Justice appointed includes retired Judge George Eskin from our community on there. So we're actively engaged with him as well. I am going to send those of you who RSVP'd an email for a SurveyMonkey to ask you a couple of questions about this. What did you like about what you heard today? And what is it that makes you uncomfortable about what you heard today? So that we can take those survey results and inform the conversation of our working group as we move to develop the rest of these protocols and procedures. My email and Angela Braun's email. Angela's done a fantastic job in organizing all of this. Thank you, Angela. And I've left business cards on the back, and some of you have already marked them up and said some really mean things. No, those are back there if anyone needs one. I'd like to thank our speakers for today, Tim Schnacky and Shelley Coran, and Mimi Carter, who's come with us from the Mark Carey Group. Thank you very much. And thanks to our AV guys for recording all this. So if you have questions, I can address them now, or you can shoot them to me, because I stand between you and the parking lot. Okay, thank you all for coming. I appreciate it.